Welcome everyone, and thank you for joining us today. As Carissa has said, I'll walk you through employment life cycle and what it pretty much is, right from the time you're thinking in terms of employing somebody to the time that they essentially leave your employment, and it's just whatever happens in between as well. So let's just start with that now. Thank you. So there are 6 stages of employment life cycles. So initial is recruitment, onboarding, it's retention, development, termination, and then finally, even after people have left, references and how to deal with those issues. So what we will cover is recruitment issues, what you should have as for new starters, disciplinary issues, ill health issues, flexible working, family-friendly policies, termination, and references. So as you can see, we start with recruitment and then we sort of filter through various issues or various elements of an employee's life cycle during their employment. So stage 1, which is recruitment, the biggest or one of the issue is to get the right candidate for your organization. And the question would be, how do you do that? And where do you advertise? What should the content of the advert include? So in terms of where to advertise, of course, you should advertise internally as well if it is relevant. But externally, you should think in terms of advertising, using as many platforms as possible. So your website, perhaps, or also possibly social media, company website, professional associations or recruitment consultants that you can use, LinkedIn, other social media where you can attract people from, but also utilize your own employees, because if they're recommending somebody, they might be actually right for your organization. So that's the sort of thing you should be looking at. In order to attract the right kind of candidate, the other thing that you should be thinking about is getting people who are like-minded in terms of looking at your core values. So your advert should include a brief mention of what your core values are, so that you're attracting the right kind of candidates who've got the same approach for your business development. It should specify or provide good details about what the job is all about, what skills you're looking for, and it should be clearly set out any benefits, etc., that you're going to be providing over and above salary, so that the job advert is attractive to potential employees. So that's what I would be looking at in terms of content. What you should perhaps not have is things like date of birth or any health-related questions, etc., because potentially you could be exposing yourself to claims for discrimination if there are any questions that could be considered as one being linked to discrimination. So any questions in relation to that, and even during interview stage, I would recommend that such questions are avoided as far as possible, so that there's no potential for a bias. So assessments and interviews. When you're carrying out assessments, there may be people who might need reasonable adjustments to be made for any interview. And again, as I said previously, avoid any discriminatory questions about sickness absence or in relation to, let's say, children. If it's a young female, you're not necessarily asking about their plans of what they're thinking in terms of having a child. I can give you an example of an issue that had happened to one of our clients who'd approached us after the event actually happened. They were interviewing over the phone, and during the course of interview, he asked about potential employees' marital statement. And the reaction he got was, well, I'm not giving you that information. You shouldn't be asking that information. And she refused to give the information, which is fair enough. He tried to explain to her why he was asking that question, in that he basically said, well, the reason I'm asking is, it is a job which is away from home, and initial first 3 months of your employment, if you were to be offered the job, you will have to be based near our head office. And the reason I'm asking is, do you have family commitments, or are you able to commit to being away from family for 3 months? Now, the question he framed, the way he framed, was not quite right. He should not have done that. He could justify what he was asking about, and the claim didn't really go very far, because we robustly defended his claim, that claim. But all of this could be avoided if the questions asked were the right kind of questions. And that's what is important from an employer perspective, to know what are the kind of questions you can ask without having any comeback. So, and that's why I've sort of given that example, because it could have costed our client quite a lot of money if it wasn't resolved at an early stage, in terms of legal costs. So yes, it's important how you deal with those. Questions about health, again, is tricky unless you can justify why it is necessary for the role that they're being interviewed for. That should not be really a question that should be asked, because it could attract potential disability discrimination claims. If once you've carried out your interviews, if you then need to make an offer, should that offer of employment be conditional or not, is something that you need to have a think about. My view is a conditional offer is always a best way to approach it. You could limit, you know, you don't know until somebody starts working for you, don't know how they will come across, how well they'll fit in. And also you may want to get references, but you want them to start straight away. So you may want to make any offers conditional to reference, conditional to successful probationary period, etc. It gives extra protection to an employer in that respect. So once you've done the first stage of recruitment, made the offer, which is then accepted, then comes onboarding of new employees. So onboarding really is the first time, you know, an employee walks into your office and you're trying to get them to trust their employer and give their 100% to the new job. So it needs to, it's a relationship building stage, and you know, that is quite important, first impressions. So the key to it would be, when they come in, make sure you've got you talk them through what the job requirement is, what is being expected of them, introduce them to everyone around within the firm, get them to know what the core value of the firm is, and how, you know, how employees interact with each other, but also make sure they feel welcomed. And you know, it is important to ensure that stage is dealt with appropriately. On the first day when they start, there is a requirement, a minimum requirement of certain documents that they should be provided. You can provide these earlier if possible, but the law requires you to provide them with all these documents on the first day. For example, contract of employment or written particulars of employment. So this should be given to them on day one. Signature, if they need some time to have a think about it and sign and return, that's absolutely fine. But it should definitely be provided on first day. Privacy notice is another thing that should be provided with, as one of the first documents that needs to be provided. It's a good idea to just sort of put it together with the contract of employment itself. And then there are other things that you should be doing, providing in terms of policies and procedures. This could be provided within an, as an installment, but you could, you know, it is best to be given or handing these out to employees straight away. Sorry, there's another person who's just joined. Carissa, could you let them in, or shall I do it?
I've got it. They should be in now.
Yeah. Okay, sorry about that. So yes, so as part of induction process, you should also provide policies and procedures, which should include disciplinary rules, equal opportunities and harassment policies, whistleblowing policy, and health and safety policy. So these are the minimum. My recommendation, though, would be that you have an employee handbook, which includes these, but also other policies and procedures, which may assist in terms of ensuring that the employees are aware of all policies and procedures and what is expected of them. Okay. So onboarding again continues. So as part of onboarding, you've also got probationary periods. And in your contract of employment, you should actually specify what the probationary period is, how long that's going to last. Are you going to have reviews, and how would it be notified that they have been successful or not? Ideally, I would suggest that written confirmation of successful probationary period or not being successful is provided. If you're providing, if you're dealing with probationary period where somebody's not been successful, I would always recommend that a formal meeting is done, following which termination letter is provided. That's a good practice. And in fact, it may be something that you need to start practicing from now on, because of the changes that the government is proposing to bring in, which would be day one right to bring unfair dismissal claims. And we will be hosting webinars in relation to the proposed changes at some point in the near future. In terms of notice period, you could think in terms of during probationary period and after probationary period, having two different notice requirements to meet the needs of the business. You may want shorter notice period if somebody's employment is to be terminated by either side during probationary period, and a longer notice period after successful completion of probationary period. So during the probationary period, keep the performance of the new starter under review. It is good practice for two reasons. One, if there is any areas that need improving, obviously it gives the business the opportunity to highlight it to them and get them to improve on. But also where people are doing well, it's a good idea to give them some feedback, because it just boosts morale of the new employee and helps them perform even better. One of the other things that you can have is right to extend probationary period. Now, quite often you will have employees who've joined and you think they can do it, but they're not quite where you're completely happy that you can sign them off as having successfully completed probationary period. In those circumstances, if the terms of your employment allow, which again, I would recommend that the contracts should have that provision, you reserve the right to extend the probationary period to give you that opportunity to explore whether the employee is suited for your business or not. Probationary terminations. Now, again, I would suggest that similar procedure is followed as you would follow with any other terminations, as in invite the individual to a probationary review meeting, give them sufficient notice, and provide them with the right to be accompanied. At this meeting, give them reasons as to why the probationary review meeting is being called and what the concerns are. Give them the opportunity to put their position forward as well at the meeting. So essentially, what I'm saying is you should follow ACAS code of practice in relation to disciplinary. And the reason you want to follow that is because you want to, one, be as fair as possible, but also you want to protect the business from any potential claims. Whilst at the moment you've got minimum of 2 years of service that somebody requires to have, in order for them to bring a claim against an employer for unfair dismissal. But there are certain exceptions under which somebody may be able to bring a claim, even if they have less than 2 years of service. But also, with the changes that the government is proposing, unfair dismissal will become a day one right, and you don't want to fall foul of that position. So you're better off doing things in the right way to ensure that the business is protected from any unnecessary claims. That brings me neatly to dealing with disciplinary issues. So whilst we would prefer, or hopefully, our employees are such that we don't have a situation where we need to deal with disciplinary issues. But unfortunately, despite every effort, there sometimes will be situations that will require the employer to look into or carry out disciplinary process. There could be deliberate behaviours of certain employees. I've given some examples here: persistent lateness, poor attitude, insubordination, smoking, which is not that common anymore, but still can be there, and which breaching policies, harassment, violent behaviour, damage to property, theft. The common theme that we tend to see tends to be harassment, violent behaviour, breaching policies, and insubordination. That seems to be poor attitude, yes, but that can generally be addressed. But insubordination tends to be a common theme as well. And persistent lateness is another of the common themes. In terms of these behaviours, some may be quite serious and sanctions would depend on that, but the way to approach it would be, in the first instance, depending on the seriousness of the conduct issue that we're looking at, you can consider how to go about it. The fair process, disciplinary process, would be to first investigate the issues, notify the employee of what the issues are and the basis on which you are raising those concerns. They should be, I mean, for the investigation meeting, you do not need to give them the right to be accompanied, but I would say it's always a good idea to give that right to be accompanied for an investigation meeting. Once the investigation is complete and you consider that the conduct issues that has been raised do need addressing, then it should proceed to a disciplinary hearing or disciplinary meeting. An invitation should be sent out to the employee with the details of the allegations, any evidence that you're going to be relying upon. Also, they should be given the right to be accompanied, and sufficient notice should be given to them so that they have sufficient time to prepare for the disciplinary meeting. A minimum of 24 hours is what I would say. Once you've gone through the disciplinary meeting, they've been given the opportunity to present their side of or their defense. You can then make a decision as to the outcome. If the outcome is to provide sanction, then such sanction is to be provided. Usually, if it is anything less than a termination, then generally speaking, apart from a verbal warning, everything else stays on their record generally for 12 months. They will have a right to appeal. And again, the appeal process would be something similar to the disciplinary process, except that the investigation stage wouldn't be there. Once the meeting for appeal is done, you provide an appeal decision, and that's the last stage from internally that the employee can go through. Unless your contracts or policies allow for additional appeal stage, that is end of the internal processes. What you should be looking at is making sure that your internal disciplinary policy and procedures are in line with current ACAS code of practice. If the sanctions are less than termination, then obviously they stay on their personnel file for 12 months, verbal warning for 6 months. If, however, it's termination, that's when there can be potentially a claim, depending on their length of service. So they could potentially bring a claim, and you need to be careful to avoid any such situation. There could be other issues during an employee's employment with the business. And that can be capability issues. And the question there arises whether it is because they can't, do the work, or because they won't do the work. And that's the issue that you've got to be looking at. The distinction would be if they can't do it, it could be for various different reasons. It could be because of their health. It could be because of their skill set. But won't do would be more of a deliberate act. So if it is a won't do, and they're sort of refusing to carry out sort of reasonable instructions, or not dealing with things as the business requires them to, then that I would deal with under disciplinary process, because it is more as a conduct. If it is can't do rather than won't do, then the way forward would be to look at whether it is performance review meeting or is it capability review meetings. Initial approach should be informal to get to the bottom of it. What is the issue that is causing performance or capability related concerns? Once you've managed to get to the bottom of it, you can then decide what approach, and if it can't be informally addressed, then you can decide how to approach this. Formal approach would be to think in terms of the first thing you need to make sure is that you're following policy, because if it's capability issue and if it is health related, you need to be really careful, because it could well be because of somebody's disability of some nature. And you want to make sure that you in compliance with what Equality Act requires you to do. And if there is a need for making any reasonable adjustments or providing some support in order to assist a disabled employee to be to perform to the required standard, then that's what you should be doing, because in the absence of that, you could be exposing business to potential disability discrimination claim. If it is not performing because they're lacking skills or they need some certain support of some nature, then again I would suggest that that is explored. They're given certain time, a period of time to improve, and you go through stages to see how things, if the things are going to improve or not. If even after you've done what you need to do, things don't improve, then of course you need to take it to the next stage, and it could essentially, if things don't improve, could result in termination of employment. Again, just make sure your policies and procedures are up to date and is in line with ACAS Code of Practice, because if they are not, and if any claims are brought against the business, then there can potentially be an uplift of up to 25% of any compensation that a tribunal may award. So we just need to be careful about that. As I said, training, support, and targets need to be sort of looked at. Training can be, if somebody's failing to achieve their performance requirements, their targets, then you need to have a think about what support they need, if they need any training. And if it's because of their disability, is there a need to consider amending or changing their targets slightly to accommodate their disability, as long as that is reasonable. You do not have to bend over backwards to remove everything. It has to be reasonable adjustments and not all adjustments. Sanctions, again, as I mentioned, it could be, employees, depending on what stage they're at, they could be given warning, and then it could culminate ultimately, if things do not improve after different stages, then it ultimately would go down to termination of employment. So again, it will be similar: verbal warning, written warning, final written warning, and then termination. That's the usual process. If it's because of sickness, then you're looking at perhaps having a slightly different policy, but it's, stage 1, stage 2, stage 3, and then ultimately termination on grounds of capability, which is a fair reason for dismissal if required. The next thing that I would deal with is grievances, because despite, as I said, all best, the employer trying their best to ensure the workplace environment is harmonious and everything is working well, there might be things that people are not happy about and wish to raise a grievance. So you need to be aware of that. It might be that two employees are not getting along well, somebody feels bullied, and they bring a raise a grievance, or quite often what we see is people bringing in raising grievance about reasonable adjustments not being made. So those could be things that can be brought about. It's essential that things are dealt with appropriately during this stage, and employee trust is, depending on what the situation is, but this is an opportunity to reinstill trust with the employee by looking at the grievance thoroughly and addressing issues, genuine concerns appropriately. If concerns are brushed under the carpet, say for example, if there is anything to do with disability related grievances and they're not addressed appropriately, the employee could potentially bring a claim for disability discrimination on the back of that. Or say, for example, somebody is being bullied and they've given a lot of information to the employer hasn't looked into it in detail and hasn't dealt with it properly. That then results in the employee resigning and maybe claiming constructive dismissal. Obviously, at this point, provided they have 2 years of service. If that happens, that again, despite the employer not terminating the employment, it exposes the business to the risk of a tribunal claim, which you don't really want to be finding yourselves in for multiple reasons. Because one, it's not good for the business reputation. Two, because it is time consuming and it will take management's time and other witnesses' time. It is a stressful process and it is a costly legal process that you would have to go through. And if you're not successful in defending yourself, then there is compensation that one will have to pay. So it is always better to try and resolve issues as early as possible rather than allowing it to go to a tribunal stage at all. Once the grievance outcome is provided and the individual is not happy about the outcome, they will have the right to appeal against the decision. And again, that will be the last stage for the employee internally to exhaust. And after that, they can, if they choose to resign or if they have standalone rights arising, then they can, the next step would be to take it externally through ACAS and then to the tribunal. The next thing that you need to think about as an employer is record keeping and how long you can keep their records. You've got to think in terms of, are we compliant with GDPR and Data Protection Act 2018? How long can you keep their information once they've left the organization? How long do you retain disciplinary or capability warnings? So these things need to be looked at, and usually, I mean, I'll get to the point of how long they should be kept later on, but usually I would say do not keep them any longer than is necessary. The other question would be, can they be used for other purposes, like, for example, redundancy selection? Somebody's got a written warning during a disciplinary process. Can you rely on that as a selection criteria? And also, what you need to be careful about, which is quite common nowadays, is subject access requests that employees can make, which means any data that you hold on them, you have to provide those to them and within a certain period of time. So be very careful of what information you have to keep and how long you have to keep, so that you know, you're not found to be so that it's in line with what the legal requirement is. So stage 3 is retention. You know, whilst we've talked about negative aspects of things, any business, we generally would like employees, good employees, and for them to have stability and continue working with us and growing with the business. So in terms of looking at how do you retain such good employees within your organization, you should look at various options, for example, flexible working, which is you know, each one of us now, our lives have become so busy, we need to have some kind of flexibility from work in order to have a right balance of work-life balance. So from that perspective, I think, particularly since COVID, workplaces have become a lot more flexible and have a lot more flexible working arrangements. So being upfront about it and, you know, looking at the needs of the employees is helpful and would assist with retention. Also, providing rewards and recognition will motivate employees, and they will, you know, they can then see their future with the business. So that's another aspect that one needs to keep in mind. In terms of flexible working itself, the question is who can ask. Essentially, now we've got a day one right to ask for flexible working. So in the past, you had to have a certain length of time before you could request flexible working. You had to be employed for a certain length of time before you could request flexible working. However, now it's really the new Labour government's policy means that they can make a request on day one. What can they ask for in terms of flexible working? So you know, they could make a request for that. They have a statutory right to make a request for flexible working. They could ask for reduced hours. They could ask for working different pattern. So for example, they could be working full-time but request to work condensed hours, so they are working on a 4-day basis rather than on a 5-day basis. They could request remote working, or they could request hybrid working, or there could be other permutations. So they can make these requests, and an employer has an obligation to respond to this, to their request within a certain period of time. And there are only certain reasons that the employer can provide in order to refuse such a request. And usually I would just say, well, it should have good business reasons to refuse, rather than just refuse because they do not want to allow somebody to work flexibly. In terms of procedure, again, I would say that the procedure should be that the request is made in writing. And in terms of any decision, the decision provided whether to accept or refuse is based on facts and not just on personal opinion. And the decision should be given within 3 months. One of the things that, generally speaking, flexible working request is made by people in order to accommodate certain aspects of life, which could mean, say, for example, it could be a female or a male person maybe asking for flexible working in order to accommodate childcare responsibilities. Generally tends to be females. If the request is declined, then there could be possibly an argument for an indirect discrimination on the basis that a female of a young mother, a female who's a young mother, has been discriminated, or the policy has been applied in such a way that it is indirectly discriminatory towards that section of female. So it's just being careful about those aspects, and also from a you know, employee perspective and retention perspective, it is, unless the employee can see genuine reasons, they will feel unhappy about a request, a genuine, reasonable request being refused. So, you know, and if they get disgruntled, they're likely to move away and find an alternative employment. So it isn't good for employee retention if we do not look at flexible working sensibly. The other thing in terms of employee retention is ill health and sickness absence, because that can cause quite a lot of difficulties within the organization. So it is helpful to have a policy in place to start with in terms of how you deal with short-term absence and how you deal with other kinds of absences. It's because the impact of absences is not just on the individual, you know, coming to work and the manager managing them, but it is across the board, because If somebody is off sick, the impact is felt within the entire team, perhaps because somebody else is having to pick up. It adds stress and pressure for others as well. So it is necessary to have right kind of policy and ensuring that the employer is trying to get to the bottom of what is causing these absences. If it's short-term absences, but it's frequent, then to try and get to the bottom of it. And if it is because of no specific reason, but you know that could then lead to perhaps disciplinary or some of the substantial reason dismissal. If, however, it is a long-standing condition, because of which the individual is having to take sickness absences or more frequent sickness absences, then that's something that needs to be considered. And the things that need to be looked at and considered is whether or not that is a disability. Even if it isn't a disability, is this something that the employer can help with if it is not disrupting the business in the same way? Is there anything that the employer can do to help the employee provide consistent work without disruption to others as well? Are there reasonable adjustments that can be made? And how that would impact the rest of the team. So these things have to be looked at and carefully managed to retain good employees, because other people's absences can have an implication for other employees who would have otherwise stayed within the business. So that needs to be carefully balanced and appropriate action taken at the right time. Medium to long-term absence, again, that's what I was talking about in terms of disability. So if somebody's got a medium to long-term absence, it could be because of disability. And again, in order to consider what steps should be taken, you probably may need doctor's report. You may need occupational health input to see whether there's anything that the business can do in order to get the employee back in work. Are there any reasonable adjustments that can be made? So all of those factors need to be looked at. It doesn't mean that the business has to bend over backwards to accommodate that individual, because the purpose of having an employee is to ensure that the business can function. So reasonable adjustments is what has to be looked at, and not bending over backwards. But it is something that we should be looking at in terms of reasonable adjustments, what occupational health input is, and what can be done to assist both the business and the individual so that the business can function smoothly and the individual is able to return to work. If that isn't a possibility, then the last stage would be termination on grounds of capability. Mental health first aiders, policies and training. So the things that could help is, if there are mental health issues, should we have some kind of, should we have people who are mental health first aiders within the organization? Should they be given some, or if we don't have anyone, should there be policies and training provided and a particular individual allocated for this? Those are the things that need to be considered. The other thing, in terms of retention, what you need is having the right kind of policies and procedures and reward incentives in place. Family-friendly rights are something that do attract and retain employees. So maternity, paternity and shared parental leave. Obviously, you've got the legal position setting out notice requirements and rights. That is the bare minimum that any employer has to give. But could you be looking, or can the business afford to give enhanced contractual rights in terms of maternity, paternity and shared parental leave aspects? Would that assist in retention of employees? Should you have a repayment clause? So if you've got the enhanced contractual right for, say, maternity and paternity period, what we would always recommend is, from retention purposes, is to have a clawback clause within the contracts or within the policy. So when they do return from the maternity leave period or paternity leave period or shared parental leave period, they have to remain in your employment for a period of time. Otherwise, they will have to repay the contracted enhancement that they've received during this period. So that's a good way of trying to retain the employees within the business for a longer period of time. Keeping in touch and reasonable contact. Again, the idea when somebody's on long-term absence from the business, if they're left to their own devices and they're not being kept in the loop, they may feel isolated and feel that they're not thought about by the business. They're not really part of the business if they've got personal circumstances keeping them away from the business. So it's helpful to have reasonable contact, and also during maternity leave, keeping in touch days to keep them feeling like they're part of the business. And holiday rights, allowing them to, if you've got good holiday entitlements within the business, it assists it is quite a good benefit that employers really do value it. And a lot of employees, when they're looking at accepting a job, look at the number of days of holiday that are being provided. It's an easy win for employers. So my recommendation would be, instead of having statutory minimum holiday, if you've got contractual holidays, which is over and above what the government requires or the law requires employers to provide, it is a good, easy win, because people still work really hard and they value their holidays. So that's in general in terms of family-friendly rights. Time off to care for dependents. Again, some of the law does not always require paid time off for dependents. Usually this tends to be unpaid time off for dependents, but you need to have a think about who are the dependents. It quite often is nowadays tends to be elderly people as well. So you're looking after elderly parent or a close relative, and you need time off because they might be, or you're looking after somebody who's disabled, who is dependent, and you need some time off to care. So again, you need to think in terms of how much time, what the policy allows, and whether that should be paid or not. And it would depend on the business and their ability, what they can offer or not, but it is something that one should bear in mind. These things make a difference because these are things that are close to employees' personal lives, and where a business is understanding of their personal circumstances, the chances of retaining a good employee is increased, and also the chances that the employee is going to give their 100% to the business in these circumstances where they're being supported. Parental leave generally is unpaid, and it is only to sort of meet parental responsibility, which has suddenly come about. It doesn't mean, say, for example, a child is taken into hospital and they need to be off for that reason. Yes, that is there, but it doesn't mean it is time given to them to try and arrange for make alternative arrangement, and does not mean that they, necessarily that they have to be given the entirety of the period off. But it depends. It is case sensitive, and it would be something that needs to be dealt with on an individual basis rather than a general approach. Stage 4, development, training and promotion. In order to get the most out of your staff, you need to make sure that they're constantly being developed and, keeping, they're being upskilled all the time, and they're being given the right training opportunities and promotions. That will help staff to feel that they're being valued, and if they feel valued, they're likely to stay with you. That also, if you've got like a pattern of how career can progress within the organization, so that helps. And if they can see or be encouraged towards career progression through training and promotion, then they can see their future with the business, and they will remain with the business. And in terms of development and training, training and promotion, again, the business should act in a fair manner and advertise these options or roles, carry out objective interviews, and equal opportunities should be provided to avoid any potential claims for discrimination. The fifth stage is when employment is due to come to an end, and it could come to an end because of an employee tendering their resignation or because an employer is terminating the employment. If the employee is tendering their resignation, then usually, I wouldn't say always, but usually the risk of claims is limited because it tends to be that people are moving for a different job role somewhere else for various different personal reasons as well. It could be any reason. But in situations where an employee is unhappy about a workplace situation, they've raised concerns with the employer, that hasn't been addressed, they may tender their resignation on the basis that there's been a repudiatory breach of their contract. So a core element of their contract has been breached by the employer, and therefore that gives them the right to tender their resignation, but claim it as constructive dismissal. The argument is, you've left me with no choice but to resign, and therefore it is deemed as, or it should be deemed as dismissal by the employer rather than resignation. So that's the only one risk. Otherwise, if the employer is terminating, the fair reasons for termination are conduct, capability, redundancy, illegality, or some other substantial reason. And I'll give you an example of what can form as some of the substantial reason. Let's say you've got an employee who is working on the business, on behalf of the company with a client of theirs, quite often within security, where you're providing security guards. Let's say you're providing security guard to a third party, and for various reasons, the third party does not want that individual with at their premises, and they're insisting that they provide that the company provides them with somebody else. And the company has no other position where they can move this individual to. That leaves them in a very difficult position, and that can be one ground for, say, one of the grounds for some of the substantial reason dismissal. Sorry. So it is not conduct by, it is not the conduct of the employee that is caused, but it is actually a third party pressure that has resulted in that dismissal. And it will be considered as a fair dismissal if they don't have any other alternative. Illegality would be, say, for example, you've got a person who's a migrant worker, and they do not have right to work in UK. That's illegality. And if you find out that, say, they had right to work in the UK and that's expired, their visa hasn't been renewed, then and their right to work has expired, then that is a ground for termination and is a fair ground. Redundancy, capability, and conduct, we've sort of touched briefly earlier, they're all fair grounds for dismissal. But what does unfair dismissal protection mean? So if you're dismissing them for these reasons and you've done gone through a fair process, then it's fair dismissal. But if these aren't the reason and you've used them as a cover or use a different reason for termination, then it may well be an unfair dismissal. At the moment, employees need to have 2 years of service in order to bring an unfair dismissal claim. However, if the employee was to, if their employment was to be terminated before 2 years have expired, they may still be able to pursue a claim against the business if they fall under a protected characteristic, and these are listed below. I'm not going to go through them because I'm conscious that because we started a bit late, we might be overrunning as well. So I'll just move to the next slide. But if you've got any questions in relation to that, do send it across to me. But just be careful that 2-year rule isn't, if somebody's got less than 2 years, doesn't mean that you can simply dismiss. I would still suggest that you follow the processes. Termination, again, once you are terminating the contract, make sure that you're in compliance with the contractual notice requirement, whether you can pay them, pay in lieu of notice, put them on garden leave. What are the restrictions, post-termination restrictions? Are there any that you need to remind them about? And make sure they've returned company property to the business. Stage 6, references. What kind of references should you provide? Should it be standard? My view is to avoid litigation, keep it factual and standard reference. It should be accurate and fair and should not refer to past disciplinary records or make reference to reasonable adjustments, etc., because that could give rise to other kinds of claims against the business. Just keep it factual, and that's the best way to go forward. Work reference should not include absences due to disability or parental rights, etc. Character reference must not be misleading or include irrelevant personal information. My view is provide factual reference, start date, end date, job that the individual does, and also what kind of, if you want to give a bit more information in terms of the job that they did. And if you want to make it a bit positive sounding, you just put that you're wishing them all the best. You can add a bit more if you want, but be very careful of, giving any opinions. You do not want people to come back and claim victimization or whistleblowing detriments on the back of references being negative. And that's, if you've got any questions, please ask me.
Right, thank you, Navya. Does anybody have any questions for us today? All right, I will take the silence as a no. If you do think of anything, please do let us know. We will be sending a follow-up email after this webinar, likely tomorrow, with a webinar recording, the slides from today, and feel free to reply to that email or contact directly at marketing@truthlegal.com to ask any questions that may arise after the webinar. But for now, I think that's it, and we'll leave you as is. Thank you very, very much for attending. Navya, do you have anything final to add?
No, I mean, the only thing I would add is that we will be doing, the government has brought in, the new government has brought in a lot of, or is proposing to make a lot of changes to employment law, and we're in the process of actually going through the changes that is being proposed. Most of it is probably going to come in April 2026, but preparedness needs to be done a lot earlier. So what we're going to propose, what we are thinking of doing is perhaps going through the topics, the individual changes that the government is proposing and its impact on businesses and how that can be sort of addressed early on, rather than the businesses finding themselves in a difficult position when the law changes. One of the biggest one is going to be day one right to bring unfair dismissal claim. That opens the door for so many people who've just been, literally, you've employed somebody a week down, you don't feel they're appropriate for the business, they're the right person, you dismiss them, and you've got potentially a claim against the business for somebody working 7 days for you. So it is very important now to have policies and procedures in place and to follow them correctly so that the business remains protected. That's the only thing I would say at the moment.
Yeah, for sure. We're organizing a webinar about that, and we're also releasing a business bulletin through the email marketing as well. So if you've joined this webinar, you are likely on our mailing list. So you should be receiving any updates about either the webinar or the business bulletin through that. If you don't think you're on the mailing list and you would like to be added, please, again, do let us know. And we really appreciate you attending today.
Thank you.
Thanks, everybody.